Your Honor, may we excuse the witness?
Yeah, Mr. Smirker, you can go ahead and step outside for us. Thank you.
Your Honor, so
Your Honor.
well, first of all, my motion is a motion for mistrial based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting, this is who it belongs to. So that was my objection. I believe the objection was well-founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for a mistrial.
May I respond?
You may.
Judge,
Can somebody put the document up? Everyone see?
yes. Would you put it up? First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with where's the phone number? There it is.
Yeah,
Okay.
the comments generally being all of the writing on the right side of the picture.
Your Honor,
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him
Honor,
to testify to that?
I'm asking him, and I understand the court, I'm asking him
you?
what handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked for. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is it?
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle. He sought additional information. The entire cross.
Number one of the comments.
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally asked that.
I asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there, and I asked for everything that was on the right side, all of the verbiage to be. I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse here. It is what it is. I think that the state was disingenuous about it. The state's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate, and I'm asking for one.
I can't figure out what it is. If it's disingenuous, if it is that, I mean, I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that. But this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back.
The court's ruling.
So could you share with us all of the whatever parts you think actually you would like to have admitted and published?
Yes.
I mean, can you do that from now on without me having to beg you to do that?
Your Honor, the court does not have to beg me for anything.
Okay, I mean, let's just have it be sort of a standard, which I thought would have been clear anyway, but is apparently not, that you make it clear to everybody what parts of what exhibits you want in evidence so that we can then, if there are evidentiary challenges to them, be able to sensibly discuss those. Is that something you can do for the court and for the opposing counsel in this case?
Absolutely.
Okay. So can you right now let us know so that while we're having our half hour, we can take a look at all of that?
Sure can, Your Honor.
All right. Thank you.
You're welcome.
And the objections, as stated already, generally were hearsay, confrontation clause, and authentication. There's not going to be a confrontation clause issue. People's Twitter posts are not testimonial. But with regard to authentication and hearsay, I don't know if
He can set the foundation and he can,
he can authenticate these.
I believe that.
Okay,
we can-
maybe. All right. And then there may, okay, so let us know. How are you gonna let us know that? Because can you email to everybody the portions, or how are we gonna?
I can give you the specific page numbers.
Okay, and everybody else has a copy?
Everybody has this. Yes. When you say everybody else has a copy, I'm not sure what the court means.
If you give page numbers, they have a copy so that they'll be able to easily find and look at what that is?
If they scroll, if they look at the
Do
that
you
they
remember?
have.
They have a link. Do you remember which link it is?
Yeah.
Can you let us know that, or at least them know that?
I'll just yes, I can.
Resending it would be great, and then
Okay.
pinpointing.
And perhaps telling us where it is in the discovery.
No, she's going to resend it, which would be easier.
Okay.
Okay, so you will do that and be specific about what parts you want in. All right, Mr. Shart, you had asked in the midst kind of all of the objections that the court give an instruction about the blank box. Is that something that you still want me to do, that the box was blank at the court's instruction because we didn't at that point have anything establishing the date, or?
Yes, I would very much appreciate the court giving
Okay.
that instruction.
And that was
because
states 44, I mean, not states, I'm sorry, Mr. Stillwell 44.
I believe that's correct.
Okay.
I can check. I'll approach and look at the evidence and confirm.
Okay, and so I'll just tell them that it was at the court's direction that the box was blank because it hadn't at the time been established what the box meant.
Your Honor.
Will
may I-
that work? Yes, no?
Yes, that would be
Okay.
great. Thank you.
Yes, ma'am.
Your Honor, that requirement of the court was not on the defendants. They objected to that box being shown. The state had no objection. So in as much as the objection leveled by Mr. Stillwell is what the court based that on, and the state did not have an objection, and the state actually explained what it was, and Mr. Stillwell could have very well put that date in the box.
No, Mr. Stillwell could not have at that point. There was an objection to it. I will give that instruction, and I'm also going to instruct that the state may not in any way attempt to argue that Mr. Stillwell was trying to hide anything by having that box on there blank. Understand? And I'm not saying you would, but just want to make that clear. Understand?
I think, yes, Your Honor.
Okay. All right, I would also, let's see. So we're going to deal with the Twitter feed issues and the reconsideration of Zachary's things. Anything else?
The additional crime scene photos
Your Honor,
from Mr. Atkins.
I don't know if we'll get to that or not.
Okay.
When would that be coming in?
not it.
Your Honor, those probably won't even come in until the next week or the week after
Well, they
next,
may not be
depending.
coming in at all.
Well,
but
if they are to come in, it would be in about 2 weeks from now.
Okay, and it was so like, you said, or somebody said that the CADs with regard to those had already come in. Can y'all be a little more specific about what those are going to be crime scene photos of and why, like what crime scenes and why? I know, Miss Love, you said, oh, you put them back because of witnesses that you had to add back in. Can you give me a little more specificity about that?
So at the begin, you want to know the actual
Crime scenes.
Okay.
And then why did you have to add those witnesses back in?
Well, the why was when counsel for
Was it because you were establishing who lived at places and they were gonna object unless you brought the person in?
That was half of it. The other
Okay.
half was that they objected to any of the,
Chain of custody, I remember.
right.
Anything
Right.
beyond that?
Yes, so I'm pulling up the actual
Okay.
incident number.
I mean, if you want to just give me an address, like the so-and-so crime
But-
scene.
But these photos, Your Honor, were not produced in discovery.
I
until-
understand.
Okay,
I'm
thank
going
you.
to get to that. I'm just trying to get a little bit of basis for what we're even talking about.
So it was 717 Cedar Avenue. I don't have the date on that in front of me.
Well,
The-
one was 2014, one was 2015, one was 2019, as I understand it. Which was that?
That was 2014.
Okay.
And that was based on an objection about the Nibin hits. And then there was the 807 Prior and 193 Hendricks shooting, which I think was that was in 2015. That was one of the retaliatory shootings. And then there was the 2019 one regarding Milton Howard in Rayshawn Lucci Bennett's vehicle
Where?
on the road. It was, the specific address was,
This is something there was just testimony about last week. Yes, no?
oh yes, I'm sorry, I thought you. Yes. That was rhetorical.
Okay, well, in any event, you say you added witnesses back because of needing to establish who lived where and the chain of custody, I guess, for like bullets and shells and things like that. But if the photos themselves were never provided, which is what Mr. Adkins represented in his email, then why should they come in now?
Your Honor, so as it relates to the scene, we believe that it's relevant information that does not unfairly prejudice anyone, as the incidents themselves are very much a part of the discovery that we've provided.
But the crime scene photos aren't, right?
Your Honor, I believe I believe that they have not, but I will make certain that they've not. I believe that they have not
Well, Mr.
been.
Adkins represented that they hadn't.
And I have no reason not to
Okay,
believe.
so you check on that in our 30 minutes or so that we're going to have, and you can let me know. All right, let's be back here at 1:20.
Your Honor,
Yes.
I know that Mr. Sprinkle had no more questions on direct by the state, so I will put in writing. He mentioned some phone calls, jail calls. The state mentioned with him, but they didn't put him in. I have some objections to portions of those jail calls, and I'll put it in writing for everybody. But I just wanted to make the court aware, just in case the state wants to, on redirect, somehow get into those jail calls.
Are you going to get into the substance of jail calls with Mr. Sprinkle?
Not today, no.
Okay. Ever with Mr. Sprinkle?
At some point, yes, after we get other, yes.
Okay, then, yep, go ahead and put those objections in writing.
I'll do it.
And one more thing, Mr. Steele, you sent over an email sort of setting forth an objection or a continuing objection, I guess, that you have to the testimony of Mr. Sprinkle about his investigation, and you based it on Davis versus State, 307 Georgia 746 from 2020, and also Adkins v. State, 301 Georgia 153 from 2017, and the law that's set forth in those about conduct of an investigation and an officer not normally, only in rare instances being relevant, but that it is relevant after, or its case law appears to acknowledge that it can be relevant after a defense has raised questions about an investigation. And yet you're saying at the same time that your co-counsel is asking Mr. Sprinkle questions about his investigation that you don't believe that it is relevant here because the defense hasn't challenged Mr. Sprinkle specifically. And that is, I appreciate that nuance, but my original ruling on that stands. So I'm going to overrule your objection. You may have a continuing objection to that. All right. See y'all back at 1:20.
Just for you to know, we speak with independent crime scene people, so the state just giving us this, these photographs, and then we have to review the evidence, and then go talk to the witnesses. It's a hassle for us.
So if she lets me know that these were originally provided, that's one thing, but if they were not, then they're not going to be coming in. All right. See y'all in 30 minutes. We're going to pause from our evidentiary issues for a minute. Thank you for coming in, and I had a question for you that is, and you may already know what the topic is. And did you take any photographs of the witness?
I did not. And from the area that I sit today, you can tell that I couldn't take that picture.
Okay.
I heard it online, and luckily I wasn't all the way back to Covington. So I don't believe in throwing rocks and hiding my hands.
Okay.
I have a reputation, and I'm going up for DOJ certification for immigration. So I don't need anything that's lack of moral turpitude to affect me. So I wanted to make sure.
Well, I
got
appreciate
back
you
in
coming
here.
straight here. And I think that we have actually figured out what happened anyway.
Okay.
And since we're on it, I'll just go ahead. And it appears that what happened is that, and I hate to say it, and I don't think it was your fault, Mr. Maurice, but I think what happened, it looks like, is that you're showing the screens when video is being played, understandably. But what happens is when the video gets stopped, there was just an instant where, because for us in here in this courtroom with Zoom, we have the witness being shown just to us so that y'all can see it and I can see it, because this courtroom setup is not ideal for everybody to be able to see the witness. And it showed for just a second the witness, because it captured the Zoom that got shown that's just interior here, but anybody, of course, can screen grab it. And it looks like that's what happened. So I think that in order to stop that from occurring in the future, we just, when we have a witness who isn't supposed to be filmed, we just won't even be able to use the Zoom, so that we don't have that accidentally happen in the future. And there aren't that many witnesses that aren't going to get shown anyway. And thankfully for this particular witness, it's not the end of the world,
Right.
considering she's apparently been on First 48 before. So anyway, thanks to all of the media people, and y'all are all still good and allowed
Okay.
to come in.
Also,
and-
I don't get that list of who's not to be photographed.
Oh,
If
and-
I had not heard it ahead of time,
yeah.
I wouldn't have known.
Okay.
But
Let's make sure
I
we get
definitely
you
wanted
added.
to make sure my name is
Okay.
good.
All right.
Okay.
Thank you.
Thank you.
And I know we added, so bad with the names, but the other lady the same day. So let's make sure she's on that list too. Okay.
Thank you.
Thank you.
I
All
appreciate
right.
it.
Back to, so R is in, R, S, Sierra. Any objection?
Sierra, we withdraw. It's in on
Withdrawn,
a different
okay.
account.
Tango, I know that one. Any objection to T? Thank you. Anybody?
I'll object, Your Honor.
All right, basis.
Nobody's disputing that these two people know each other. I'm assuming the court knows who they are. If not, I could tell you. And then the writing, I'm being told, is just quoting a lyric from a song. So I'm objecting to the writing as well. I don't see how that furthers anything.
I don't know if the lyric from the song takes the C and change it to some other letter, but this is Kelvin Treadwell, whom the witness discussed during the interview. This is January 18th, 2015. We believe it's relevant. There's nothing unduly prejudicial, and we'd ask that the court allow it to be shown.
And where's there a substituted
No.
B?
Oh, BITX.
Oh,
H.
I thought you, okay,
ES.
X. Okay. All right, I'm gonna overrule that objection. You.
This is a different time. This is even further into 2015.
We have a picture of these people together already.
We have various pictures of them together, but in this particular picture, Mr. Sledge, who has testified, is throwing up the B for blood. Shannon Stillwell is right in front of him, and Mr. Zachary is immediately to Mr. Sledge's left. We believe that this is a pertinent, and we feel like there is persuasive power in the depth of presentation. And to say that we have one, I'm trying to quote
No,
a
go
case.
ahead. I'm sorry, I just have this ringing in my ear all of a sudden. Go
To
ahead.
say that we have
You're right.
one picture or two pictures of the three of them together
Okay.
already.
All
doesn't-
right. Overruled. V.
That was inadvertently added.
Okay. V. W.
This is Mr. Zachary and Mr. Stillwell. This is March 2nd, 2015. He tags Mr. Stillwell and he makes a proclamation. Our argument is that given count one in the language and description of the conspiracy, it is evidence of Mr. Zachary promoting YSL and promoting Shannon Stillwell and attempting to assert their dominance. He's a gangster. He's not scared of you. This is him tagging him and him posting him.
Your Honor, I'm going to absolutely object to a piece of evidence coming in written by someone not my client, that's not my client apparently, about my client, calling him a gangster. That is prejudicial. It's not in furtherance of any conspiracy. It's not my client's words. It's any probative value is outweighed by the, I mean, we're charged essentially with being part of a gang.
Mhm.
And a gentleman who did testify, but who also was off the stand by the time the state announced specific intention to use this photo. Calling my client a gangster? No, I'm objecting.
He would have lied if we asked him about it in any event. He said that everything he said about anybody was false.
Well,
Anybody in this courtroom.
I'm not interested in what he would have done. I don't think any of us know what he would have done. But the bottom line is he was on the stand and off the stand by the time the state announced their intention of using this.
And Your Honor, I think that
Go ahead.
I was just going to say that this was captured in 2016. Mr. Stillwell was tagged. And I think that it's relevant and admissible and not unduly prejudicial.
All right, I'll let you admit it without the I don't know what you call it, tagline or commentary or whatever. I mean, you can leave the at Shannon, but the he's a gangster, he's not scared of you. They didn't get a chance to, and I think that you are probably correct in what you surmise would have been the testimony, but they didn't have an opportunity to ask him about it. So you can leave the at part, but
Yeah.
yes.
Does Your Honor not consider it an effort on the part of a YSL associate, as the state alleges, Mr. Zachary, to assert the dominance of a member of YSL? Even if it's not taken as true, he's asserting something.
I understand the argument. All right. Do you understand the ruling?
Absolutely.
Okay. X. Any objection?
Did you, before you talked to Mr. Zachary, did you in any way alert Mr. Zachary by any member of his family or any other way to the approximate number of vehicles that you saw in that video?
No.
Outside of the investigation that was conducted by Detective Dennis in that Little Wayne bus shooting, did you have independent information that about the details Mr. Zachary gave you during that August 5th interview around this Little Wayne bus shooting?
No.
Do you know whether Detective Dennis had information during his investigation that could corroborate or disprove parts of what was being said?
I'm not sure.
Have you ever had interviews where you're sort of forced to decide or determine whether somebody is trying to put blame here to get blame from somewhere else during your time as an investigator with the gang unit?
Sustained.
Okay. During your interview with Quindarius Zachary, did he give you any indication that his reason for talking to you was to get Shannon in trouble and get Demikian or Woody or Muntu out of trouble.
Objection, Your Honor, bolstering
Speculation.
and speculation.
Uh,
Thank you.
Yeah.
Overruled is to speculation. Overruled is to bolstered.
You may answer that question. Do I need to ask it again?
No, I think I understand it. No, it didn't appear that he just wanted to get them in trouble. I took it as he wanted to try to help himself as much as he can by providing truthful information.
Speculation.
Overruled, well, sustained is to speculation.
Okay.
I also have a motion, Your Honor.
You have a
Motion.
all right. Time for our morning break anyway.
Your Honor, at this time, I'm going to move for a mistrial on behalf of Mr. Stillwell. We have, first of all, I'll point out that we've been referring to Ms. Gaither as, I believe, Sergeant, and I say that to say that she is not someone that just came off the street to testify with no understanding of how the process works. She's experienced. She's, I'm sure, testified many times before. She just informed the jurors that her belief is that Mr. Zachary did not want to harm Mr. Stillwell specifically, but that's not my objection. My objection is she testified his intent was to come in and give truthful, to get himself out of trouble by giving truthful information. That was absolutely improper. That was vouching for a witness. That was bolstering. And that is the basis for a mistrial. From an expert, I'll point out as well.
Your Honor, my response is that the court very well could and should instruct the jury that as to the witness's opinion about a interviewee's, well, first, my response is we vehemently object to a mistrial. Secondly, the court could and should instruct the jury that a witness's opinion about another witness's statements or, testimony or anything that they said is not to be considered by the jury. The jury is the person that determines the credibility of the witnesses. And I can make certain that Sergeant Gaither knows when I'm asking regarding any indication that to not talk about truthfulness, but just to give objectively what indication or whether she considered that there was an indication. Secondly, a mistrial is in no way warranted in this case when Sergeant Gaither did not say Quindary Zachary was being truthful. She said, I perceived. She said, I perceived. And that is why an instruction would be warranted that her opinion about his truthfulness is not to be considered by the jury. They make the determination about credibility. There is nothing about any of the exchange that just occurred that warrants or in any way justifies a mistrial. At best, an instruction is called for.
That I initially objected to the question to begin with, and I saw the danger, and the state insisted on asking that question that prompted this response. That was completely inappropriate.
All right, thank you. I'm going to instruct the witness as well. So we'll go ahead and take a break. And when we get back, I'm going to have the witness in and instruct her and then give an instruction to the jury. Going to deny the motion for mistrial.
Your Honor, I'd like to renew my motion for the next question.
All right, thank you. All right, we're on recess.
Assume we're all joined in that.
Yes.
Okay, thank you.
I mean, yeah, 10 minutes. And by the way, that witness, Bernie, if he's not here already, he's on his way, the one who needed to testify in Cobb. So just in terms of scheduling, if y'all want to take him next, he's available. And I knew that we wouldn't be done with this gather anywhere near 10 a.m.
I won't feel offended.
Yes. I'm just trying to draft this. Okay.
Then I want to go back to the original question I asked about the allowing Mr. Copeland to speak with Mr. Garlington on a non-recorded line, okay?
I don't believe I stated.
I'm sorry to interrupt, Judge. May we approach briefly, please?
Yes.
I'm going to ask you to address the witness and speak to the witness, and also, quite frankly, to speak to the DA as well. Because of the way everyone is positioned, they're obviously closer to the jury than anybody else. Their microphones are live, and what they say can be picked up on a microphone. A couple of times.
Sorry, who? The state says at their table?
And what the witness is saying. And there have been at least 3 occasions where the witness has either before or after a question muttered something and said something into the microphone that can be picked up.
Well, I certainly haven't heard it. I can barely hear the answers.
I am not the only one who's heard it. At that last exchange, I heard her say something, I couldn't make out what she said, into the microphone. I guess she was frustrated after the question, and it's being picked up by the microphone, and if I can hear her muttering over here, whatever she's saying can be heard to the jury, and it's just inappropriate. I think it's simple enough to tell her to not make any extraneous comments that can possibly be picked up by the jury. Same thing for the state. And we've actually addressed this before prior to this court's involvement in the case, where there have been times where the state, either out of frustration or who knows why they're doing it, says something or they're making faces and they're saying something that can be picked up by the microphone. And because they're that close to the jury, I'm sure the jury can hear it too. So I'm just asking, as I've asked before, and as they have been told before, to be mindful of the things that they say and the fact that it can be picked up by the jury.
I can't say that I heard this because I was in the middle of everything, but I've been told by multiple sources that once my cross-examination was finished and Mr. Steele was going to begin, the witness said horrible.
Horrible?
Horrible.
What? Okay.
And she's sitting right next to the jury.
If the witness and or the state is saying things like that and the jury hears them, I cannot imagine that reflects well on either of them.
Your Honor, I have to say, I would ask that presumptions based on assertions by counsel for opposing for the defendants not be taken as true and then spoken as if they are by this honorable court, because I have no idea what Mr. Adams is talking about. I have not heard any mutterings. I don't know what Mr. Shard is talking about. The state does not have the luxury to sit here and say what it believes someone from the defense is doing without it being cut off quickly. So I'd ask that the court not act on what is being asserted by counsel for the defendants as we stop these proceedings to address something nobody heard, but apparently Mr. Adams.
Fortunately,
And Mr.
this
Sharp.
trial. Fortunately, this trial is televised.
And Your Honor,
You know what? I'm going to stick with what I said before, which is if a witness wants to present themselves in that way in front of the jury, that is a reflection on that witness, and the jury can evaluate that. So, no, I'm not going to advise her or any other witness one way or, well, depends on what they say. And I didn't actually hear anything, but no, if she wants to make derogatory comments, then that is a poor reflection on her. And the jury, if they heard it, will notice it. And to the extent, I mean, I haven't, was that basically just about this witness?
It was about the witness and about the prosecution. And let's be
Who's
clear.
doing this, or you believe is doing something like this right now?
Yes, and who has done it before? I'm not just saying that. The court has addressed it before because it's happened before. So we're not making this up. She was admonished previously by the prior court to stop doing that.
And you're saying she's doing it again, and it is making faces and or comments.
Making faces, making comments. It can be picked up by the microphone. These mics are live. And as Mr. Shard pointed out, luckily, this trial is being televised and live streamed.
I don't know why that's lucky, because the jury is not going to watch the live stream.
I'm not talking about I'm saying
I mean,
that
the jury is the one deciding this case.
the person making the complaint about the behavior is the defendants. And I'm in support of what I'm saying. I'm telling you that we are not the only ones who have noticed this. That's all I'm saying.
Okay. Well,
Your Honor, and I would ask, I have asked that the microphone not be close to counsel's table over here behind, so that
which microphone are y'all even talking about?
anyone that can pick up conversation at the state's table, because I'm not trying to have our
No, it shouldn't be. You all,
That's-
any attorneys ought to be able to talk to each other at their table privately without anything being picked up. So I don't know if that means y'all want to turn off your mic, because we're in a big, awkward courtroom where nobody can hear anybody sometimes, but then apparently people can hear mutterings under the breath other times. So
we have it off. I've unhooked this, even though it was off. I don't want anything said at counsel table heard.
all right.
Period.
And then I don't know what the situation is with the mics that are on the back table, whether those are off.
No,
They're offline.
Okay.
Sometimes what we learned the last time, if that mic is on,
That mic being the podium mic, which has to be on.
so we have to be more conscious. Sometimes the podium mic can pick up our conversation because we're closest to.
Mr. Maurice has something to add, and maybe he knows because he's a media guy.
We are not picking up our conversations. We can hear a witness. She's left a couple remarks towards the end of her.
Y'all, I guess because y'all are plugged straight into the system, y'all get to hear way more than we get to through the ambient air.
But we're not picking up any of their
Okay.
conversations.
okay.
Okay, well, I mean, I wish we could hear as well as the live stream apparently can, but there's nothing that can be done about that. All right, anybody need to use the restroom while we're on a break? Go ahead and do that now. And do we, I mean, it doesn't matter, I guess, but do we think we'll get through this witness today? Are there going to be other defense attorneys with cross? And then is there going to be redirect? I guess we'll just see what happens, but,
To answer your question, at this point, no.
okay.